Okay, Burry,
Yes.
what is the rule for prior consistent statements?
Oh my God, this reminds me of first week of law school before I did any reading. They used to call, remember they used to go, did your profs call you out?
Wasn't that called the Socratic method?
Yeah.
The only class I had that in was tax 1 and 2.
Uh-huh. Oh my God.
And it was great. I loved it. I probably was the only person I know in my year who loved the Tax Act.
You're insane.
And I should have become a tax lawyer. I would have been retired by now. But
wow.
I loved it. And he always he used to go, Neuberger? It was like all the time.
Okay, I have to tell you my tax exam story.
All right, go ahead.
I hated tax with a passion.
Oh, it was great.
I know you loved it. It was mandatory at Western. I hated it. I was criminal law god, and I had a friend who was tax god, so we got along great.
Yeah.
So I said, night before tax exam, come on over. You're gonna teach me the 5 things I need to know, and you're gonna do it with food association. So there was, what was Section 85 rollover? There was some...
Oh, rollover of assets.
Right.
On it. Yeah.
I said, what? I remember that. So I said, how are you going to make me remember that? He said, well, just think of an apple turnover. I said, beautiful. I love you. So I go into the exam all cocky with my materials, bound in plastic still. I'd never opened them, ever.
Oh, my God.
So I sit there.
I would have died. I would
know,
not
yeah,
have been
I know,
able to.
I know.
I have nightmares of that still.
Oh, I lived
like
the
waking
nightmare.
up like I haven't cracked my textbook.
No, this was the nightmare. So the exam starts. I'm sitting there. I got 2 Snicker bars and a pile of materials that have never been opened. So, of course, I ate the chocolate bar first. And then I open up the materials, and everyone's looking at me. What the hell is Burry doing? And then they're laughing.
I can't believe you did that.
I did this. So I open up the materials. I'm looking through them. Get a couple of paper cuts, and I said, screw that. So I read the exam. You remember those 15-page fact situations on those exams?
Yeah, yeah.
I'm reading over it. It's the nightmare, you know, the nightmare where you get the exam, you have no clue what it's about. I lived the nightmare. So I'm looking at it for an hour. It was a 2-hour exam. I spent an hour just flipping through it, going, interesting. Had my second chocolate bar. And then it's like, oh my God, I got an hour left. So I just start scribbling gibberish. Like, it was just gibberish. It looks like Section 85(1) might apply, but I'm not sure, blah, blah, blah. And then at the end of the exam, I wrote, Dear Professor, you probably know who this is. Please pass me. I promise I will never practice tax law. And this was this young, cocky tax prof, God, right, he saw me in the hallway a few days later and he said, really? I said, I don't know what you're talking about. I said, just pass me. He did. I got a 52 and life went on. So that is my tax story. Yeah. Look at Joe. He's in shock.
Don't hire Michael
hire me for
in
any
case you're charged under the Tax Act with tax evasion or.
Please don't hire us for that purpose.
No, you can hire me. I got an A+ in both courses.
Yeah, wow.
And I did commercial law for like 15 minutes of my career.
Oh my God.
Which had tax work involved.
I think I walked by a commercial firm once. That's about it.
No, I articled. I was with John Rosen.
Yeah.
During a crim intensive program. It was great. I sat in on 4 homicides. I said this before. This is where I learned a lot about cross-examination. And John, one of the best cross-examiners ever. And I loved it, and I did great. And he offered me an articling job. He said, you should try civil, because if you hate it, you can always come back. But, you can make a lot more money in doing. So I went. I had summered at this law firm, and I returned as an articling student, and I enjoyed my commercial rotation. I hated my litigation rotation because there wasn't really much litigation. They kept giving me like somebody's son got charged. That's what it turned into. And I got hired back as a securities lawyer. So they were like, doing deals and stuff, and there's always tax stuff. And if you're doing back then we did an offer memorandum, prospectus deal, stuff like that. So I was involved in it. I liked it, but I just didn't want to do it. So I quit after 3 months, and I went back and just did criminal law. But I liked tax. Tax was fun.
See, my
because it was this giant, thick code, but like everything was in there.
I know, it's one book.
And this is one thing I'll say about a law degree. And if you take an open approach to your courses, like I took trusts.
Ooh, that was painful.
No,
go on.
Constructive
trust.
Loved that stuff. I took that, business organization, securities, evidence 1 and 2, criminal law. Like I did all of it. But it really gives you a pretty good understanding of the business world and life. So if somebody tries to you over later on in life in business or something else, you're pretty well equipped if you've done that type of. I had somebody who interviewed with me a billion years ago when I first opened, and we had a mortgage fraud case. And so I just popped the scenario out, and they literally looked at me stunned, and I said, you took property law, but did you take real estate because I hadn't gone through the I hadn't gone through the transcripts from law school, and I asked for them, but I didn't go through it in great detail. And she's like, "Oh no, I didn't take real estate, and I didn't take much business courses. I just took all satellite law and basket weaving and feminism and
law and space law,
the feminist perspective on satellite law."
Yeah.
And so I was like, "So you really don't know how commercial mortgages work and underwriting of a larger, but no, I have no clue." I said, "Well, you're not going to get hired then."
No, you're not. Have a nice day.
And Maria will tell you. So Maria, one of our lawyers, will tell you when she came to me as a summer student, and Alan Young, who's outstanding lawyer.
Great guy.
One of my favorite professors, had referred Maria, and this is a long time ago. And so I said, "Yeah, I'm gonna hire you for articling, and then probably as an associate, on one condition. I pick your third-year courses."
Oh, wow.
So I forced her to take trusts, business law. I think I forced her to take real estate.
Ooh.
Because it just gives you, that's why I loved so much about the legal education. It gave you a great view of so many things. And it really equips you well. Even if you don't practice, it's just Okay, let's talk about what we're really here to talk about. Sorry, I digress because it just brought me back. When you're talking about rollovers and stuff, it just brought me back.
See, I used the distraction technique I used to use in school.
That was a good one.
Yeah. See, I got at least 10 minutes out of this. But
all right. So what's the rule on prior consistent statements? Because we keep coming back to this every so often because it's a difficult area of evidence.
Right. Here we go. And I can't say it better than it's said in one of the cases we're going to be talking tonight. So, prior inconsistent statements are generally inadmissible.
I promise I'll never practice tax law.
Yeah, it's true. And I didn't.
I feel like I need to give you a Snickers before you answer.
Could you?
Okay, go ahead.
I don't think we have any here. Okay, so prior consistent statements are generally inadmissible. Why? Asked the judge. Because lies can be repeated just as easily as truths. Therefore, a witness's evidence is not rendered more I know you're going to tell me to slow down.
No.
Oh, well, normally you do. Therefore, a witness's evidence is not rendered more likely to be true simply because the witness has said the same thing on a prior occasion. In the normal course, these types of statements are entirely self-serving, superfluous? I can't say.
Superfluous.
Very good. And lack any probative value. This reminds me of my kids when they were younger. They can say as many times, "But I didn't do it, but I didn't do it, but I didn't do it." That doesn't mean to me you didn't do it. All right. So that's kind of in a nutshell what that means. Repeatedly, I didn't do it, I didn't do it, I didn't do it. That doesn't make it more true. We're saying I did do it, I did do it, I did. Repetition doesn't make something true or false. There are a few exceptions, but typically that's the rule with respect to prior consistent statements. They're generally inadmissible.
Well, and let's just say this, just to make it more complicated. So there are exceptions.
There are.
And they include prior consistent statements as circumstantial evidence. Mm-hmm. That's a difficult one.
It is.
Recent fabrication, not so hard. Prior consistent admissible hearsay. That's a difficult one. Prior consistent statements that provide context for admissible statements. Pure narrative. Narrative as circumstantial evidence.
This is reminding me of the
exculpatory. This is why evidence is like.
It's hard.
Exculpatory statements when found in possession of contraband, which forget for our purposes.
Right.
Exclusionary statements made on arrest, identification evidence, and also admissions against interest.
Right.
And what also is important is, even though a piece of evidence, a prior consistent statement, may be admissible under one of the exceptions,
yeah.
The law doesn't permit judges, decision makers, to just simply let it in and just sort of figure it out. They're let in on a restrictive basis.
Right.
And we'll talk about that later on. But
well, let me give a little example just so people kind of understand what these exceptions amount to. So one exception is a prior inconsistent statement is admissible when an explicit or implicit suggestion is made to a witness that they've made a previously inconsistent statement about a particular point, when in fact they made both inconsistent and consistent statements. So what that means is, if I'm cross-examining someone on a prelim transcript, for example, or their statement, and I'm just focusing on the inconsistent statements, but there's also previous consistent statements, it's not fair to them from a judge's perspective that I only get to cherry pick the inconsistent statements. Both have to come out, to be fair.
Bless you. So let's
Bless you, Marcy.
Let's actually lead with that case, because this is a good one, because somebody sent me an email and a suggestion asking about, tactics for cross-examination. How does the Crown sometimes deal with it? So let's take a Court of Appeal case, Regina versus GS 2023 ONCA 712. And this was an interesting case where it was a historic allegation of sexual assault. And the complainant had said that the sexual assault started with her being 13 years of age and went to approximately the age of 15. And the person, this happened at a place where she worked, which was a bakery. And she had not disclosed this for obviously a long time. And then came
20
forward
years,
about,
I think.
Yeah, it was 20 years. And we've talked about challenges with respect to historical allegations, but came forward with the allegation. And the complainant had said that she was sexually assaulted on 3 separate occasions, 2 in the delivery van and 1 at a residence. And the exact details of it are not material for what we're talking about. But the complainant gave a statement to police, which was, a recorded statement like we normally have. And then also, because it involves a charge of sexual interference, under the criminal code, it's the one area where a preliminary inquiry can be held.
So bottom line is 3 potential versions of her evidence. So we got her initial statement to the police 20 years ago, testimony at the preliminary hearing, under oath, of course, and her testimony at trial under oath. So 3 different scenarios where she is presenting her version of the events.
And just again, to be clear, so in sexual assault cases now, because they're punishable up to 14 years in jail, there's no preliminary inquiry. As we've said a billion times, that was gone with Bill C-75. Mm-hmm. But where the complainant is underage at the time, oddly enough, if you want to protect somebody from having to testify multiple times, you might want to deal with those who are more vulnerable than others.
Vulnerable young kids,
right? Whatever. So this person had a preliminary inquiry, and the complainant testified at the prelim, and the defense lawyer cross-examined on inconsistencies between what she had told police during her initial statement and her in-court testimony at trial.
Which is what we do quite often. That's quite normal. It's nothing nefarious there.
Perfectly fine.
Right.
And so it's a legitimate, and it's what we do. If you find inconsistencies, but in particular material inconsistencies between in-court testimony and a statement, that is low-hanging fruit. That's stuff you're going to cross-examine on, absolutely. But you have to be careful that depending upon how you go about that cross-examination, it may give rise to an allegation of recent fabrication, meaning that you could say the complainant said X in the statement, but they altered their evidence at trial in order to make it more plausible. Therefore, that is a recent fabrication. Mm-hmm. One of the ways of dealing with that is, in this case, the lawyer argued, no, I'm saying this was fabrication ab initio right at the beginning. The problem was the defense lawyer had said that specifically the complainant had intentionally changed the evidence at trial to make it more plausible or believable, which then gave rise to recent fabrication, which in and of itself was not necessarily the guiding principle for the judge to follow. But what the defense lawyer did not do was what?
Well, he didn't. He only examined her or cross-examined her on the inconsistencies between police statement or testimony at prelim.
And the Crown attorney stood up and objected.
Right away.
And said,
that's not fair.
It's not fair because the complainant testified at a preliminary inquiry. And those inconsistencies that the lawyer is raising were actually mentioned at the preliminary inquiry. So there was prior consistent statements at the preliminary inquiry.
Right.
Very important.
Well, yeah, court says Crown Counsel raised the concern that while there were inconsistencies between the complainant's trial testimony and her police statement, her evidence at the preliminary inquiry was the same as her trial evidence. So the Crown sought permission to re-examine her on the consistencies between the prelim and the trial.
And what's important here is that the Crown had raised this objection during cross-examination. So the lawyer was, I assume, alert to, of course, the transcript of the prelim, and was obviously alert to what there were, to being prior consistent statements, but was now certainly put on notice by the Crown that they would be seeking to re-examine on prior consistent statements. And the defense took the position that you can't do that.
Ultimately, the court said, I see no error in permitting the Crown to elicit evidence about prior inconsistent statements from the preliminary inquiry.
And this is really important from a trial tactic standpoint. And I'm just addressing somebody who asked this question. So when you want to cross-examine on inconsistencies, you have got to deal with the evidence you don't like as well.
Right.
So if there is evidence where somebody said something consistent, you are walking down a very dangerous path by not addressing that in your cross-examination. You've got to bring out the good and the bad if it's going to impact you negatively.
Right.
You have no choice. You've got to face it.
No, or else this is going to happen.
It's going to blow up.
It's going to blow up. You're going to get railroaded, and you lose some credibility, I would argue.
Yeah.
It doesn't look good.
Yeah. I mean, look, I understand why people make judgment calls, and they may feel in that particular moment that it's not right for what the judge to do. But clearly, this is one of those exceptions. Yeah. If you draw inconsistencies, the Crown can cross-examine on prior consistent statements because you're raising the issue. It's available. Period. That's one of those exceptions. We'll talk a little bit more about that later on, that it's not just carte blanche, but it is. And so it's a better tactic then to try and tune your cross-examination to address the preliminary inquiry evidence in this instance, and then address the inconsistencies and make something of it.
Have you had that come up where it's been like,
oh yeah,
this is really good, and ooh, there's some bad stuff?
Yeah, so you have to do, it's a good question. So you have to weigh the value of everything. Right. So if you see this great inconsistency, but then you go, here's this preliminary hearing transcript or another statement where they're completely consistent, you might go, I don't have that much value in it anymore.
Right.
It's sort of neutralized. Or you might go, okay, hold on. Why did the person say this then versus their preliminary inquiry and trial evidence? So let's pause for a moment. Let's just say hypothetically, a statement is given 20 years after the fact. That statement says that, sex occurred in the bathroom. Prelim trial, sex occurred in the bedroom. That is something you can't not cross-examine on.
Right.
So you might say, you would think about it to say, I just want to be clear, both at trial and at the preliminary inquiry, you've indicated that the sexual assault occurred in the bathroom. And you were very sure of that. And the prelim occurred on June 15, 2022. So it was about 9 months to a year after you gave your statement to police. Is that correct? Yes. Okay. So we're clear that you have now placed the sexual assault in X.
2 times.
Twice. But when we look at your statement, which is really your first opportunity for going to the police after 20 years, you're very specific about where you say it happened. And that is not in where you said at the trial and prelim. And so you can make more of it.
Oh, yeah, I think so. Like, why? I'm just failing to grasp why they didn't do that in this case. Trial counsel. Not a criticism. I'm just trying to understand the strategy. Like,
whatever. Like,
you have to address these issues, right?
Yeah. Like, I don't see a way around it.
No.
But whatever. I mean, but from a trial tactic standpoint, you got to be able to not just identify an inconsistency, but you got to identify what will happen to me once I go down that road.
Yeah, what's the value?
What else is going to happen? It's literally like a game of chess. You got to think. That's why we draft out our cross-examinations,
3 moves ahead.
And sometimes it looks a little bit like snakes and ladders because one way the witness goes, you may need to go this way or you may need to reference that. You've got to be very careful about it and think it all out ahead of time. So I think, it would have been better, but clearly the lawyer thought, I'm allowed to do this because I'm saying it's fabrication ab initio.
Right.
They should not be able to get in the prior consistent statement. The trial judge disagreed and found in favor of the Crown being able to re-examine.
Right.
And the Court of Appeal also upheld the trial judge's decision, but slightly differently. And there's a really good point here.
Which one?
So this is interesting, and this is why...
Several good points in this case.
Why don't you raise one? But there's something that I think that's very important that is too easily missed.
Well, the judge said that this is all about trial fairness regarding this witness. You have to be fair. You can't try to take advantage of a witness because it's just greasy. It's going to backfire on you.
Trial fairness is a legitimate reason to get it in.
Right. So that stood out for me in terms of one of the reasons why the judge allowed it, and it just makes sense, right? Like you can't just present part of the picture when you're presenting a picture. You have to present the whole picture.
Correct. And so it was very important. This case stood clearly on credibility, period.
He says, she says, classic.
So when a witness's credibility is attacked on the basis of prior inconsistent statements, the question becomes whether a prior consistent statement can assist the trier of fact in making a more accurate assessment of the witness's credibility by taking away any potential erroneous impressions fostered by an incomplete picture of what the witness has previously said. That is the reason for admission. And you have to keep in mind, we've said this a million times, even though some people want to suggest it's not, in sex assault cases, and in the majority of them, credibility is the central issue.
That's
period.
Typically the only issue, as far as I'm concerned.
Well,
there's others, but
but sometimes they're really, even though you don't need corroboration, sometimes there really is. So you got to be careful about that. So the judge didn't really need to admit it on the basis of recent fabrication, but regardless, it was appropriately put in.
Yeah, the judge allowed the Crown to re-examine on that point. She was recalled, and the Crown was allowed to ask her about the consistencies.
So what's important also that the Court of Appeal notes here, which I think is sometimes not followed carefully enough, and we all have to be alert to it, because trials move quick, there's a lot of dynamic, your cross may change, you got to be alert to issues. But even where an exception to the general rule of exclusion applies on prior consistent statements, trial judges must remain on high alert when dealing with prior consistent statements. This is because even where an exception applies, a risk of prejudice can still flow from the admission of such statements, particularly when unaccompanied by a strong jury instruction. So this was a jury trial, and the jury may use the prior consistent statement for an improper purpose.
Right.
Therefore, after finding of admissibility is made, it remains incumbent upon trial judges to consider limiting how the prior consistent statement is to be elicited. And that's why I mentioned at the beginning, there is restricted admissibility even under these exceptions. And
so what does that look like? What page are you on? This is interesting.
I'm on page 16.
Okay.
So this includes assessing whether the full, this is important.
It is.
It gets lost. And because I had this happen in a case where
really?
The Crown was trying to, it's not because I stepped into a landmine.
No.
But the Crown wanted to admit a prior consistent statement for trial. I was trying to explain at trial, it's admissible.
Right. But
you don't need to put in the content.
Right.
So this includes assessing whether the full content of the statement or just part of it needs to be elicited to achieve the purpose of the admission, especially when you're in front of a jury.
Yeah.
And indeed, it includes determining whether it's sufficient to simply elicit the fact that a prior consistent statement was made without actually placing the statement before the trier of fact.
Right, because that statement can contain a bunch of other stuff.
It can. And here's the folly that you can get in, or the mischief it can play in front of a jury. A jury might very well believe that because it's been said more than once, it must be true.
That's what we started with.
That's still a problem with prior consistent statements, even if it's admitted under one of the exceptions. Mm-hmm. And so what was really interesting in this Court of Appeal decision was that the majority found, all right, well, I guess they were all in the majority here, that it was sufficient to elicit from the complainant that she had testified at the preliminary inquiry in a manner consistent with what she had said at trial.
Right.
Full stop. That would have been enough.
That's all you need.
So, the moral of the story is, even where there is an exception for the admission of prior consistent statements, you got to be careful about still having, if it's a jury, limited instructions and being keen to what needs to be admitted.
No, for sure. You don't stop at step one. There's step two, obviously, as we've seen.
Now, let's go to a more stark example about this.
Oh,
okay?
you love this case.
Because it's amazing how, and I understand why, judges, lawyers, we all struggle with it at times. Some of these exceptions are so challenging to understand, and one might wonder whether it's really worth it in the end. There probably is a better way of dealing with it.
Yeah.
Justice Pachaco, I think, talks about that a little bit in his article from a few years ago. But anyways, there's a case, Regina versus Morin, Morin, 2024, ONCA 562. It's a Court of Appeal decision, great bench.
Yep.
And it's, something which is in our wheelhouse again. The appellant, it's not our case.
No.
The appellant was charged, and that you call the accused the appellant on appeal after they're convicted, on a multi-count indictment with abuse allegations of a domestic partner. Okay, so there's multiple allegations.
Historical assaults.
Yeah. And sadly, the individual was not represented at trial, so he's representing himself, which presents, acute issues for the trial judge. They have to be alert to the fact that that person is going to need extra care because they don't have the benefit of a lawyer being able to deal with evidentiary issues, how to ask questions properly on cross-examination, etc. And it just so happened that while this person was testifying, they came out with this swath of text messages spanning a time of these allegations that he sought to admit as evidence to support his position.
Right.
That was an issue because, one, that would be something that, although it's not a sex assault case in this particular instance, it was just physical abuse, not a sexual abuse.
Right.
I'm not saying that's not bad, it is, but anyways, if you want to put these messages in a non-sexual assault case you've got to confront the complainant about it in cross-examination.
Right.
You got to give the complainant the opportunity to explain about these messages. It's what we call about the Brown and Dunn
Brown and Dunn
rule.
It's getting late.
I'm tired.
We're all tired. It's been a busy week.
In any event, so the poor fellow doesn't know that.
He doesn't know, of course
After
not.
much discussion, the judge said, yes, we're going to allow it in.
And there was a particular message about, let me read it here. The trial judge then stated, there are also contemporaneous text messages that confirm that the appellant broke things such as counter and a glass and threw a bottle at the complainant's head when she would not stop talking when he told her to do. But the bottom line was that it was not appropriate for her to use that because that was only in a text message. She hadn't testified about that.
Yeah, so that's a good point. So let's just break it down a little bit more. So the judge allows a number of messages to go in through the accused, but then also allows the Crown on cross-examination to admit additional text messages that were provided by the complainant.
That's right.
Okay, and the trial judge at the end of the day found that the accused was completely unbelievable, not capable of raising a reasonable doubt, and the complainant was 100% credible. And the trial judge, which is what you were just suggesting now, used some of the text messages that had been put into evidence by the defense and some in cross by the Crown at several points in her reasons as referring to these messages as corroborating evidence of her in-court evidence or contradicting the appellant's trial testimony. That was the big folly.
It was. And especially, the comments she ended up making. The trial judge concluded that because of this, the complainant was entirely credible and rejected the appellant's evidence as wholly unbelievable and not raising a reasonable doubt in her mind. That's kind of scary.
And what's important here is normally if a judge gives full reasons but makes mistakes like this, you can use the curative proviso. So like you'd say, like these were clear errors, but if you read the entire decision, the judge instructed herself as to what the limits are for prior consistent statement, and had all these other reasons to reject the complainant's evidence, reject the accused evidence, blah, blah, blah. So in the end, it wouldn't have affected the verdict. But the Court of Appeal says, since this was a two-witness case, much of the trial judge's assessment was on the respective testimony credibility of the complainant and the appellant. So again, credibility was the central feature, which means it's not one of those cases necessarily when there's such a big up here that you can use that provision. They found that, in fact, it would not be an appropriate case.
Right.
And what was even worse was the court had used, the trial court, unfortunately, had also used the prior out-of-court statements for the truth of their contents, which engages the hearsay rule, regardless of whether the statements were consistent or inconsistent with the witness's in-court evidence. Another big no-no.
Yeah, it was interesting because they also said, this is, in short, this is not a situation like another Supreme Court of Canada case. They said the trial judge's reasons in this case expressly state that she was treating the complainant's February 27, 2013 text messages as both corroborating and confirming the complainant's own in-court testimony and as contradicting the appellant's denials. We cannot conclude that the trial judge did not mean what she said or infer that she must have only used these text messages in some different and legally permissible manner. So the Court of Appeal basically said, it's not good.
No, it was a very, very strong judgment. And again, it reiterates what's important about restrictive admissibility, and it's something which can easily be missed. You know, the presumption that prior consistent statements are inadmissible is subject, as we've said, to multiple exceptions. Even when a prior consistent statement is properly admissible, they can say, on more than one basis, care must be taken to ensure that the trier of fact does not misuse it to draw logically or legally unsound conclusions that depend on prohibited reasoning. And that's what happened here. And there's just one other thing. I'm sorry if I'm talking a lot here, but
okay.
And you were right on. There's just so many text messages. They were just so badly used.
Yeah. Well, he was unrepresented. Poor guy.
I don't even know if it. At that point, I don't know if it would have made a difference if there was a lawyer there who would have said, "Your Honor, no, this is completely incorrect," because this is at the time. Even if you made fulsome submissions, this is why we do written submissions. So we would address prior consistent statements and the law, right, to try and not f it up. But there was palpable errors here. The trial judge made comments suggesting on their face that, in fact, that she was using these statements for an improper purpose, including the corroboration of the in-court testimony. Yeah. It's noteworthy that the complainant's evidence was also corroborated by other evidence, such as the text messages.
Yeah.
It's just not, you can't do that. And as you noted, referred to several specific messages, one of them which was incredibly erroneous, to a specific text message in which the appellant admitted to losing his temper, describing this as confirming the complainant's testimony that the appellant had a bad temper. Since the appellant's own text messages were admissible for the truth of their contents, why would that be?
Well, because he led them.
And if he says something
against his own interest,
so there's an admission for if you as an accused have your own text message and you say, "I'm sorry, I f***ed up, I got angry and I yelled at you," that can be admissible for the truth of its contents because it was something as an admission against interest. However, the trial judge went on to use it for purposes for which she could not, and there's just tons of examples here.
Examples of that, and you know what? You're right. The court really Court of Appeal came down hard because, as they say on paragraph 41 on page 14, although trial judges are presumed to know the law, this presumption does not entitle appellate courts to ignore what the trial judges actually say in their reasons. A corollary of the judicial duty to give reasons is that when reasons are given, they should generally be taken seriously and at face value as an accurate reflection of their author's thought processes. While appellate courts should not be too quick to speculate that a trial judge has misused evidence that is both permissible and impermissible uses, and this is important, they equally cannot ignore clear statements by trial judges indicating that they have used evidence improperly. That's a big red flag.
Yeah, and so this was an important statement by the Court of Appeal. I think this is, an important decision. it just underscores sometimes how hard it is to truly understand how you use text messages in a trial, how you use WhatsApp messages or whatever you have in a case. But you can't always assume that the trier of fact will be using it correctly.
Right.
Not because they're intentionally wanting to get it wrong, but because it's a complicated area of law, which underscores why we do these. Like in a case like this, we would absolutely do written submissions and have several pages dedicated to the law and how the evidence can be used, because you just can't take a risk with this.
It's easy to slip up, regardless if you're a judge or not, or lawyer or not. It's a complicated area.
And so the Court of Appeal was very strong, as you said.
Yeah.
They can't conclude that the trial judge did not mean what they said or infer that she must have only used these text messages in some different and legally permissible way. And they noted that there was no instruction to herself here, because normally you'll see in reasons a judge will say, I've instructed myself as to what are the appropriate basis upon which I can use prior consistent statements, such as, and they may give some examples.
Nothing here.
That didn't happen here. And as we noted before about the
Proviso?
the proviso, this court has noted that caution should be exercised before invoking the proviso in cases turning on credibility. I want to just end with that, because we fight almost on a regular basis trying to explain where we get Crown attorneys or complainants counsel saying, well, credibility is not really the issue here. It's all about consent. No, it's credibility, and it can be about various factors, not just about the actual acts that happened.
And
that the
reliability.
complaining about. And so it's very important. They know just how important the credibility contest is in a criminal case. So caution should be exercised before invoking the proviso in cases turning on credibility. In this case, where the core disputed issue was credibility, the trial judge's use of the text messages was an essential part of her reasoning process. Accordingly, they overturned it, sent it back for trial.
That's huge.
It's huge. It's an excellent decision from the Court of Appeal. One would hope that this type of error doesn't happen often, but it's a good cautionary case. It's a good cautionary case to all of us to make sure that we really apply our mind, because we think about it very carefully about how these messages need to be used.
Yeah, it's not
especially when we want to introduce them.
right, and it's not just a message dump. People.
That's right.
Here's all the messages. You figure it out, Your Honor. No, we really look closely at every message and make an assessment.
You have to, because you can really walk into trouble.
I call it rabbit holes.
Yeah, I mean, we get messages from clients and they give us 1,000 messages, and you look at them and you try and determine what's really relevant. Now that we get what's relevant, what's the pros and cons of this? How are we going to use it? How can this come back and be a problem for us? And then we may also worry about, we need to make sure we have a full coherent set of messages, because
That's another
we
thing.
don't want a piecemeal fashion, because we want to be able to know if there's something lurking out there that may come against us. And then you have to determine, how are these going to be used? How can the Crown then rebut that?
Right.
And
No, this was just a dump by this poor guy. He was not represented.
but he was a representative.
That's what I mean.
It's not his fault.
It's not his fault. No.
A court owes extra caution when an accused is
Well,
not represented. Anyways, it's an excellent decision.
Yeah.
It's a complicated area, and people often ask, we get these inquiries about, tactics of cross-examination, how are messages used, how not to use them, and then prior consistent statements keep coming up time and time again, because in so many of our cases, we have these messages. So this was, again, I'm sorry if this was an overly legal analysis podcast, but, these are two very interesting decisions which addresses one question that was raised by one of our viewers.
They're important because of all the digital evidence we're now getting.
Yeah.
Didn't used to happen as much in
And
the
law
olden days.
Law of evidence is complicated.
It is.
I'm going to do pillow talk for this
Your
one.
turn, yeah. I did the pillow talk last time.
Pillow talk. Don't forget to like, comment, subscribe, and share. Thank you very much for all your viewing. We're getting a lot of emails, which is great. So keep it up. It gives us ideas for a podcast. And I promise we're going to get to that Chat GPT one.
That's right. ChatGPT's coming up soon.
And then I want to get to that online harvest bill.
And feel free to approach us in the court hallways. I had a fanboy approach me.
Okay,
It was great.
Okay. Good night, everybody.
Good night.